Each week, we cover pressing topics that matter to you and your business. My name is Ariana Gonzalez. I'm the Client Services Manager here at Chug Attorneys and CPAs, and please join me in welcoming partner and attorney Diya Mathews from our Edison, New Jersey office. Hello and welcome, Diya.
Thanks, Ariana. Great to be here.
Thank you so much for taking the time to talk to us about this topic. So for today's topic, we're going to be talking about consular processing of employment-based immigrant petitions. Once again, thank you, Diya, for being here with us. First question, let's talk a little bit about consular processing. What is consular processing employment petition and when is it necessary?
Right. So Ariana, consular processing, I think we're all familiar with it in the context of family-based petitions. But of late, we are encountering more employment-based immigrant petitions, which have to be consular processed for a variety of reasons, like people having to relocate abroad because of the pandemic and things like that. So, so I guess to explain it, there are two approaches to processing green card applications, right? After an I-140 or an EB-5 or any other type of employment-based petition is approved, if the applicant is already here in the US in some lawful status, then they can pursue adjustment of status, which is like a simple status change in the US. But in cases where the applicant happens to be outside the United States, then they would have to do consular processing of that petition. Which means that then you have to work with the National Visa Center or the NVC, wait for an interview to be scheduled at the consulate abroad, and then wait for an immigrant visa to be issued. Usually the immigrant visa is issued for about 6 months, and then the applicant has to enter the US using this immigrant visa. And at that point, they would be admitted as legal permanent residents or green card holders, as we say.
Perfect. Thank you so much for that great description of how to start the process and what it involves. So typically, I know each case is different, but how long does this process typically take? And what would you say are the steps involved for a successful consular processing?
Right. I wish I had a ready answer as to the exact time frame. And now with the pandemic, I think everything is up in the air. 2 years ago, I could, give you some sort of a timeline, but, these days it's all over the place. It comes down to this, right? That normally when we file the I-140 or the EB-5 petition, we can indicate in the application that we wish to do consular processing. And if the employment petition has been properly filed indicating consular processing, then normally what we would do is that, once USCIS is done with it, then we wait for USCIS to pass on the petition details to the National Visa Center. Then NVC sends us an email informing us that they have received the case from USCIS and they are ready to process the case from their end. This comes in the form of an email from NVC, and they'll have an invoice with the case number. So NVC will generate its own case number, and then they'll also send you the invoice. So usually for employment-based cases, the IV processing fee is about $345. Once this is paid, it will give us the option to complete the form DS-260 online on the NVC portal. Once that form is completed or in parallel, the applicant also has to upload all the supporting documents. Unlike family-based cases, for employment-based immigrant visa cases, there is no affidavit of support fee to be paid. So it's really just the immigrant visa processing fee. And then once the fees are paid, the forms are all completed, and the documents are all uploaded, the case is deemed to be documentarily qualified. And at this point, we're just waiting for NVC to schedule an interview at the consulate. Now, the problem or the conundrum is that even after a case is documentarily qualified, it can take months or even, unfortunately these days, more than a year for them to schedule an interview at the consulate. I'm pretty sure I have cases that were, completed and documentarily qualified at the beginning of 2022, and those still haven't, they're still waiting on the interview because with the pandemic, the consulates are backlogged, and they prioritize some of the family-based cases, like the immediate family cases are prioritized, but it seems that the employment-based cases are not getting prioritized. So So very difficult to give a timeline, but, I guess what I tell applicants is don't, wait on anything, just, submit whatever you can and finish all the steps that you need to, so that at least it's in queue for the interview.
Perfect. Thank you so much for that wonderful information. Definitely very helpful. Make sure you are following through with the process, regardless of the time it's taking to get through with it, especially during this time right now that they're so busy. So for everybody just joining us, welcome. Today's topic, we're talking about consular processing of employment-based immigrant petitions. Quick disclaimer, I'd like to remind you all that we are live on Facebook, LinkedIn, and YouTube. This conversation is for informational purposes only and does not create an attorney-client relationship. So please send us any questions you guys have in the comments, or feel free to email us at info@chug.com. Once again, thank you, Diya, for being here with us. Could you speak a little bit more in detail about the documents needed for consular processing?
Yes, of course. And this is, this should be done properly. If you look at it, the system is designed such that all the necessary documentation can be collected by NVC before the interview, right? So they want the interview process to be as efficient and streamlined as possible. So all the required documentation is meant to be uploaded on the NVC portal well ahead of the interview. And you have to take the originals of these documents to the interview. But when we do the NVC part of it, the NVC uploading, we have to send clear copies of all the necessary documents. The idea is that nothing should be outstanding for the interview. Primarily, it is for an employment-based case, it's going to be really just the birth certificate of the applicant, marriage and divorce decrees is applicable, any court or military records. And then, last but not the least, the infamous police clearance certificate, or the PCC, right? So, just taking a step back and I guess talking a little bit more about, the birth certificates and, the other documents, personal documents which are required. The format and the availability of these documents tends to vary from jurisdiction to jurisdiction, right? Different countries have different available documentation in terms of, how they record births and, other civil matters. So the source for us is the reciprocity schedule. So the US Department of State maintains a reciprocity schedule, and they've listed out the documentation that they expect to receive from different countries. If you take India, for example, it'll say that birth certificates are generally available after 1970, because that's when registration of births became mandatory in India. So if it's somebody who was born after in 1970 or afterwards, they will be expecting either a birth certificate or what we call the non-availability certificate. This has to be obtained from the municipality, and I think we have an entire session just dedicated to birth certificates from India. So for anybody who's interested, but yeah, so the birth certificate is important, and along with the birth certificate, if it is incomplete, your school leaving certificate, your PAN card, and things like that. Also, in some cases, affidavits, from people who are around. How we do it, NBC will send a cover sheet when they send you the initial welcome email with the invoice and everything. They will also send you a checklist of the documents that you are expected to provide. Now, not all of them would be applicable, right? So you have, for example, as I said, the affidavit of support is not really required for employment-based cases. So you have to, in some cases, you may have to explain that this is not required. Also, if there is, you can mark off the checklist and indicate that certain records are not applicable to you. Now, even after you do a very good job of submitting all these documents, NVC might come back with a question or two. And so, you might, so you will get a notification on the NVC portal saying, submit your W-2 or submit, some additional document. So you have to keep an eye out for it, and then upload those documents, as needed.
Thank you so much, Diya, for letting us know about all of the documents needed and making sure we keep a lookout in case they request more documents from us. And for anybody watching, if you did hear Diya mention that if you do have an Indian birth certificate, make sure you check out our video regarding that topic so that you can have more information on that. Thank you so much for that answer, Diya.
Actually, Ariana, if you don't mind, can I take a minute to talk a little bit more about the PCC, because we get a lot of questions about the police clearance.
Please go ahead.
Thank you.
Thank you.
So up to a few years ago, whenever the PCC was required, we would remind our clients, don't get the police clearance certificate, although it is, termed as such. Don't get it from the police station, don't get it from a local police station in India. It is, the correct authority for issuance of the PCC in India is the passport clearance office, is the passport office. So that's where you have to get it from. And of late, the process is streamlined. There's actually, you can actually go online and apply on the website, and you provide some information about yourself, and the PCC comes through. So that's, made things easier for our clients in India. The other, good measure, I guess, is that the PCC is now good for 2 years. Earlier, I think it used to be for 6 months, but now the PCC is deemed to be good for 2 years. So even if there is a delay in the scheduling of the interview at the consulate, after you obtain the PCC, you don't, it will not trouble you too much, because it's good for 2 years. You also have to get the PCC from every country where you've lived after you turn 16. So, if you've been in multiple countries, then make sure you start the process in advance to get the PCC from all those countries. And NVC will cross-check, because on the DS-260 you have to give your biographical information, listing out all the places that you've resided in. So they will cross-check, and they'll ask you for the PCC from the corresponding places. Important to note that you don't need a PCC from the United States. So even if you lived in the United States previously in some other visa status, you are not expected to procure a PCC from the United States. I guess the other thing is, in some cases, NVC will actually ask you to mail the documents to them instead of uploading it on the portal. Though that's not very common, but in some cases they'll ask you to do that. So read the NVC notice very carefully to see what the instructions are. Thanks, Ariana. Yeah, that's it on the documentation part.
Thank you so much, Diya, for diving into all of those details. I know that will be helpful for everybody watching. So next question for you. Can I work while my consular processing is pending?
No, unfortunately not. And, so consular processing, because, you're just waiting on the consulate abroad or the embassy abroad to schedule the interview. So it doesn't give you any interim work authorization or any kind of interim work status in the US in the meantime, right? So if you wish to work in the US while consular processing is going on, then you would need to, pursue some other basis like an H-1B visa or an O1 or something like that. So, in that sense, I guess consular processing presents a disadvantage compared to doing an adjustment of status in the US, because when you do an adjustment of status in the US, and of course you can do that only if you've been here in lawful status. But when you do an AOS, adjustment of status in the US, you do get some interim benefits like the advanced parole and the EAD. Unfortunately, with the consular processing, no such interim benefit.
Great to keep in mind. Thank you for that information. So you cannot work while your consular processing is pending. So Diya, when would you say a Form 824 is required?
Yeah, that's, I think a discussion topic in itself. And the 824, sometimes people confuse it with the 864. So the 864 is the affidavit of support form. And the Form 824, in the context of consular processing, is filed when we want to convert a case from adjustment of status to consular processing, right? So initially, when we file an employment-based petition, like I gave the example of an I-140 petition or an EB-5 526 petition. So when we file the initial petition itself, we can indicate whether we want to pursue consular processing or adjustment of status, right? So if the petition was initially marked for adjustment of status, and then you later on wish to convert it to consular processing, then you have to file a separate application with the USCIS, that is the Form 824, to convert it to consular processing. And the form itself is, I'd say, fairly straightforward. But the problem with the 824 is that the adjudication timelines, can be all over the place. We have 824s which have been approved in 2, 3, maybe even I think 1 month. And then there are others which have taken like over 2 years, right? So, so the 824, I think we should avoid the 824, if possible. But, there are some situations where you cannot avoid it. But for example, if the applicant happened to be in the United States when they started the green card application, and then they had to relocate. So in such cases, you would necessarily have to file the 824. And I always tell people that, like it can take, between 2 to 24 months, and just be prepared for the wait. The 824 is also required in some cases where, the principal applicant, the main applicant, if they have been in the US and they have adjusted status in the US and, become green card holders, legal permanent residents, but their dependents happen to be overseas, right? So, I have clients who say their, children, like their sons and daughters are studying abroad, they're in, maybe college overseas, and they don't intend to come to the US until they complete college. So in such cases where the dependents are overseas, for them, we would have to file a separate 824 application to get what we call the follow to join benefit, right? And the follow to join benefit is simply, that they are applying as derivatives of the principal applicant, but the dependents being overseas, we need a separate 824 application to seek consular processing for the dependents. Okay. Yeah, I think in that context, one more, I guess, sub area to be discussed is the CSPA, the Child Status Protection Act arena. Because, and as you know, Valentine's Day this year was pretty exciting because the USCIS just announced in a new policy memo that they are going to take a more beneficial approach to the CSPA calculation. Yes. Right? They said that instead of table A, they're going to go with table B in terms of the calculation. So I think you'll probably have to do another session on that if you haven't already done. But yeah, so going back to the Child Status Protection Act, the Child Status Protection Act is meant to afford certain protections to children from aging out, right? Normally, the cutoff is 21 years for, a son or daughter. But you can have some of the time is subtracted. And the other thing that is pretty clear in the CSPA is that they don't want anybody to be sitting on their benefits, right? So if you're applying for a son or daughter abroad, you can't take too long to apply for the 824. You have to do it in a timely manner. And so, it's in fact, I tell people that it's better to just file the 824 concurrent with the adjustment application of the principal in the US. So that way you're not wasting any time and you've put in the application because they will take that into consideration when they're doing the CSPA calculation. Yeah.
Perfect. Thank you so much for the details on that, Diya. So for everybody just joining us, once again, we're talking about consular processing of employment-based immigrant petitions. Once again, just a quick disclaimer, we are live on Facebook, YouTube, and LinkedIn, and this conversation is for informational purposes only. It does not create an attorney-client relationship. Please submit your questions below in the comments or email us at info@chug.com. Thank you for watching. Diya, next question. So I'd love to hear a little bit about the consular interview process. What is it like and how can we prepare for that?
The interview itself, yeah. So I think the interview tends to be a little anticlimactic after all this preparation. Yes. In my experience, most interviews have been straightforward. There's really not many surprises because most of the work has already been done at the petition adjudication stage in the United States, right? So if it's employment-based, they've verified the employment of the credentials of the applicant. So, all of that stuff has been, the big stuff has been taken care of. And really at the at the consulate interview, they are looking to verify, just that it's the same person, that it is, they will look at the originals of the documents that you submitted, like the birth certificates, the marriage certificates. And you do have to carry the medicals, right? So when you go, you take the originals of the birth certificates, the passport clearance certificate, and then the medicals, very important. So the other requirement is that you have to schedule a biometrics, appointment before the interview itself. In many countries, they will give you the interview date. That's decided by the NVC or the Department of State. But within a few days before that date, you have to separately schedule a biometrics appointment for yourself. So there's a lot of homework that they give you in the appointment notice. So I encourage everyone to review that very carefully and get things started early on, because it can take some time.
Thank you for that, Dia. So I'd love to hear a little bit of some insight of yours from your personal experience with this. What are some common challenges in the consular processing cases that you've run into, and how do you typically handle them?
How much time do you have?
Maybe just a brief overview.
Right. So I think the main problem is NVC itself, because NVC is clearly overburdened by all of the work. And communication with NVC is also very difficult, because earlier you could email them. Now they don't even I think it's very difficult to get somebody on the phone. Earlier, at least if you waited an hour on the phone, you could hope to speak to a live agent at the end. But now I don't think that option is there. You can't email them. All inquiries have to be routed through what they call a public inquiry form on the website. So communication itself is very difficult with NVC. And the other issue with many cases is that after USCIS is done, excuse me, with their side of things, they're supposed to pass on the case to NVC within a reasonable period of time. It used to be 30 days, right? But now NVC is saying that they need 60 days in order to actually receive the case from USCIS and start processing things at their end. In some cases, and I have cases, I think, which have been, 824 has been approved. NVC should have opened their case, but it's not been done for the past, 1 year or so. And we are following up, we are emailing different, there are some, I think, specific emails, like if you qualify for an expedite, or if a case, somebody is aging out and things like that, there are specific emails email addresses that you can contact at NVC, but those are of very limited, applicability. So the issues with NVC, and then I guess the other issue is after you submit the documents, right? You have to wait for the NVC analyst to review the document and make sure that it is good. So the status changes from submitted to accepted once NVC reviews the documentation and agrees that it is fine. But even that is taking well over 2 months for some cases. And then I guess after the case is documentally qualified, which means that NVC has informed us that they don't need anything more from us. Then at that point, we're just waiting for the interview. And then, as I said, the interviews, there's no visibility like on how or when they will schedule the interview. We have cases, sitting for, I guess, close to 2 years now. And so those are some of the, I guess, the pet peeves with working with NVC. Another thing to keep in mind for all applicants is that NVC, if they don't hear, they're supposed to send you a warning, like an intent to terminate letter, and then if they don't hear from you, then they'll terminate it within if the case has been dormant for 12 months. So the best way to keep the case active is by contacting NVC on a regular basis. I encourage people to do it at least every 6 months. If you so keep in touch with NVC, and this is only for cases where you've not paid the fee and things like that. But just make sure the case is active in the NVC portal.
Perfect. Thank you so much for that very helpful information, Dia. Make sure your case is active. Don't let it be dormant for 12 months and expire. So what happens if the visa application is denied or refused?
So fortunately for employment-based cases, that doesn't usually happen. At least, I've never had, one run into that situation before. Because as I said, most of the, work has already been done on the case and eligibility has been established. So unless there is some issue of, fraud or misrepresentation or something, normally an immigrant visa, based on an employment-based based case should not be denied or refused. What has happened is sometimes there are mistakes as to the aging out of children, right? So the Child Status Protection Act, the CSPA, protects children from aging out in some cases. So I've seen sometimes the consulates get those calculations wrong. And in that situation, we would have to, what we would do is we would write to them and we would, explain the calculation in very, simple, basic terms. And then if they still don't agree, then we would have to, pursue, the next step, which is going to a legal net. So technically speaking, the consular officer's determinations are not, they cannot be reviewed or they cannot be challenged. But if it is an error of law, then you can go to legal net and ask them to review the case and reopen it.
Perfect. Thank you so much for sharing that. So typically, how much does this process cost, and is there a way to expedite it?
So the first part, yeah, that's the simple part. The fee actually is, in a way, I think consular processing is, I would say, cheaper than doing adjustment of status in the US, because the fees, the NVC immigrant visa fees, is about $350. And then you pay an additional USCIS fee of $220 when you, get your visa stamped and you're entering the US. So, it's not a lot. But I guess, in terms of expediting it, that's where, it's, there are very specific reasons for which they will expedite a case. So normally I've had pretty good outcomes when we requested expedite because, children were aging out. But otherwise, they are not very good with expediting cases, because I guess everybody thinks that their case needs to be expedited and nobody wants to be waiting 2+ years. So they probably get a lot of requests for expedite, but they don't entertain them too much.
Thank you so much. That is definitely helpful information. So there are exceptional cases, but typically there is not really a way to expedite it. So would you say there are any potential risks or challenges of consular processing that people should keep in mind?
There are certain situations where you don't have an option, right? And you have to do consular processing. So for the, if you're physically outside the United States, when your immigrant visa comes through, your petition comes through, then you don't have an option of doing an adjustment in the US, right? You have to do consular processing. And so I guess no risk as such, it's just that, you have to be prepared for a long wait. And I tell people these days that unless you're prepared for a 2-year wait, don't do consular processing if you have the option to not do it.
Perfect. Thank you so much. That's very helpful. We do have an audience question that we want to end with, so we'll take that before we close off. So do you have any tips to maintain the green card once we are granted it?
So after the person comes to the US, okay, so let me go back a little bit. I said, after you do the interview with the consulate, you get your passport back with the immigrant visa stamped in it, and that's usually for 6 months. So make sure you enter the US within that 6 months, right, using that immigrant visa. And when you do that entry into the US, at that point, you are entering as a green card holder. So you don't really have that permanent resident status until you have utilized that visa stamp to enter the US. Once you come into the US, normally they'll mail you the green card. It's supposed to come within a month or 2, but sometimes it takes longer. But that will come. I mean, and the green card is, the LPR card really is just documentary evidence. But, irrespective of whether the card comes or not, you are an LPR at the point that you enter the US. Once you come in, then there are requirements as to maintaining the green card. The first one is, I guess, in terms of physically being in the US, you have to make sure that you consider the US to be your home. They want to see that you're not just visiting the US, but you actually live here and you're domiciled here. Travel is fine up to a point. So, the minimum is you should not be away from the US for a year or more. So if if you have a lot of travel, then I suggest you come back before you hit the 12-month mark. So 12 months. That's the first thing. That is just in terms of maintaining the green card. Now, if you wanted to, preserve the time towards naturalization, then you have to actually be here. You cannot be away for more than 6 months. So two, different sets of requirements. And then, of course, don't get into trouble. Don't do anything that can get you deported. So, yeah.
Perfect. Thank you so much, Diya, for your time and expertise and sharing all of your knowledge with us. This does bring us to the end of our conversation. So thank you so much, everyone, for joining us. To stay up to date with us, please subscribe and follow us on Facebook, LinkedIn, and YouTube. And if you have any questions or suggestions, please reach out to us at info@chugh.com. That's info@chugh, CHUGH.com, anytime, and join us back next week for more pressing topics that matter to you and your business. Thank you, everyone. Stay safe and take care.